When a public figure falls, two questions matter most. What was known and when? Who is responsible and how? And today, Prince Andrew is not only a private scandal, he's a public test of whether our institutions prefer comfort to curiosity, privacy to probity. First, the record. From the late 1990s through to 2019, Andrew was both a working royal and, for a decade, a trade envoy. And during that period, his association with Jeffrey Epstein and Ghislaine Maxwell is documented in flight logs, calendars and photographs. And from 2019, he told Newsnight he broke off contact after New York in December 2010. Yet emails surfaced showing contact into 2011, including the jaunty promise to play some more soon. That single line is the loose thread that's begun to unpick the whole jumper. If that claim was false, what else was embellished, omitted, or flatly wrong? Now, the latest allegations, it said that he asked a protection officer to obtain personal information, dirt, about Virginia Giuffre, whose date of birth and social security number he reportedly had got hold of. The Metropolitan Police is looking at that. If the request was made, was it refused, recorded, and reported up the chain? If it was refused, why did no one warn the palace that the prince was straying towards an improper use of police resources? If it was not refused, why not? Either way, the logs exist and the truth is recoverable. Turning to the palace, between 2008 and 2019, the risk profile around Epstein was not obscure. A conviction in Florida in 2008 should have triggered a red light in any competent risk system. Did senior courtiers challenge Andrew's account before the Newsnight interview? Did anyone scrutinize diaries, travel lists and correspondence? Or did deference smother diligence? A modern court cannot have it both ways. It cannot trade on the aura of duty while pleading ignorance of its own working arrangements. Then Whitehall. As a trade envoy, Andrew moved through embassies and departments with briefing books and visit lists. Did anyone in government raise formal concerns? Were any travel restrictions applied? And if not, why not? If so, where are the papers? This is not a witch hunt, it's administrative housekeeping. Money matters next, because money always does. Royal Lodge is not a fairy tale, it's a lease. The terms now public show a 1 million premium and at least 7.5 million in refurbishments in 2003, with rent set at one peppercorn if demanded. Occupation until 2078, a small compensation if surrendered before 2028. Legally watertight perhaps, but politically flammable. When the public sees a 30-room house at a token rent, while an allowance has been cut and titles lie dormant, it sees one thing above all: exceptionalism. If the Crown Estate judged those terms to be value for money in 2003, it should say why. If circumstances have changed, it should say how. Sunlight is not radical, it's routine. Which brings us to accountability. Personal first. Andrew denies wrongdoing, yet the contradictions are his, not ours. His emails, not ours. The reputational wreckage is his, not ours. Contrition has been scarce. Litigation ended in settlement without admission. If he wishes to claim moral standing, he can begin by offering to assist investigators with what he saw, where he was, even as he maintains his denial. That is what a minimal moral compass would suggest. Institutional accountability comes next. The palace has taken a symbolic step by announcing that Andrew will not use his titles and honours. Symbolism matters, symbols teach, but symbols without systems are stagecraft. If the palace wants to draw a line, it must draw up a protocol. What happens when a working royal becomes a reputational liability? Who decides? On what evidence? With what publication of reasoning? Trust once spent is brought back in pennies and only with paperwork. Constitutional accountability is the third leg of this three-pronged stool. If Parliament wishes to act, it must do so by general rule, not by personal bill. Create a clear statutory mechanism to remove peerages and honours for serious misconduct with due process and a right of reply. Clarify the route for removing a person from a line of succession, noting the need for consent across Commonwealth realms, and spell out the limited but real power of letters patent to restrict the style of prince. bring principle to bear so that future cases do not rely on private bargains. What then should happen now? 5 practical steps. 1. Publish a bounded archive. Invite a former judge to review royal household records from the working royal era that touched travel, meetings and risk assessment. Protect security when needed, but default to disclosure. 2. Resolve the protection question. The Met and Royalty and Specialist Protection should examine the 2011 episode, determine whether the request occurred, what was done, and whether any boundary was crossed. Then publish a short factual report, no theatre, just facts. You cannot have it both ways. You cannot deny that protection to Prince Harry and give it to somebody who abuses it. 3. Clarify the lease. The Crown Estate should explain the commercial reasoning for the peppercorn structure and set out today's options. If a buyback or variation is contemplated, show the public value case, not simply the legal possibility. 4. Regularize sanctions. The Palace should adopt and publish a sanctions protocol for working royals, linking defined triggers to defined consequences. Private rebukes look like private indulgence. 5. Cooperate with external processes. If further Epstein files are released in the United States, the Palace should not hide behind jurisdiction. If Andrew can assist as a witness, he should say so and do so. Now allow me a reflection. The case is not merely about scandal, it's about the character of institutions that serve our name. The Palace wants attention on duty and service. Good. Duty without candour is performance. Service without scrutiny is ceremony. If modern monarchy is to command respect rather than request it, it must choose daylight over discretion, process over personality, rule over exception. And in the end, the questions are simple. Did you know? When did you know? What did you know? And if the answers are honest, the public will accept hard truths. If the answers are cloudy, no title surrendered, no lease defended, no carefully crafted statement will wash. The public has given its verdict on the interview that began this downfall. History will give its verdict on how the palace, the police, and Parliament finish it. I hope the verdict reads as follows. They faced facts, they fixed systems, they put principle before pride and procedure.